Thank you very much and good afternoon to everybody. On behalf of Tek that I'm representing to Gupkin University, I thank you for the opportunity that we have to join so prestigious university and to have the possibility to introduce the chair that we jointly agree to have with other colleagues. Again, I'm, as you will see later on in my introduction, as Tek as a professor in the campus university in Italy, I think it's very important to have this kind of relation with the university, having the opportunity to link the business community to the academic community. So for you, for all of you students that are, if I remember well, quite near to the end of your journey inside the university, it is a good occasion to join with us what will be your next future in the business environment, in the new arena that you will play with. I wouldn't like to bore you about my biography that you can for sure see by documentation. I don't know if Alessia is able to share our presentation. However, in a very scientific way, I'm dealing with the academic university since latest 90 years, starting from Florence and Rome University, and then around 2010, I obtained the chair in Campus Biobellico, that is the Faculty of Chemical Engineer for Sustainable Environment in Rome. This is very important because if you think that nowadays we are talking so much about sustainability, and your country, your big country, Russian Federation, is looking for to support energy transition as well, you can imagine how it was important on that years, I'm referring to 2010, to develop a faculty in the sector of chemical engineer with this claim, this payoff of sustainable environment. However, apart this, for sure, we were able also with the support of Alessandra Mangiapane, that is acting as a tutor in this chair, to bring to our students in Italy the experience of Tek Group. Let's allow me to give you some small information about Tek Group. Are very important because we'll introduce to you who we are and the management team that also will be part of this joint, let's say, teachers and tutors team to this course. It's a company, Tek Group, that mainly was established by two important entities, Italian entities. One is coming from Fiat Group and the other from Montedison Group. So the first one is mainly famous in Russia for to be part of the development of the national car factories in this country, in your country, throughout Fiat car factory, while the other one, Montedison, most probably more interested for you, was the, let's say, Italian company that started in 1933, so quite a century ago, to bring technology in your country, establish some, let's say, representative office to support the development of industrial in petrochemical and fertilizer project. So this DNA that we have in the company allowed us to develop step by step, you can see in the chart, a very important group that in 2005 was bought by an Italian entrepreneur, Mr. Fabrizio Diamato, that then in 2007 listed to the Italian Stock Exchange, and then again adding bricks by brick, building this big house, arriving till our let's say period with another important green piece of the puzzle, the establishment of NESCAM, that it is our company deputed to the development of energy transition. So you can appreciate that we are a group that in a way it's very flexible, very agile. It's trying to respond to the business community, to the business requirements, and the NESCAM is the last answer to what the business community is worldwide asking to us. Going on with our structure in a very fast way, you can see Maire Tecnimont Group, that is the listed company, is holding many companies. One of the most famous is Tecnimont. I'm referring to this company when I was mentioning the first presence in Russia. Then again KT, that is specializing in the refining and hydrogen production, but also on sulfur recovery and process heaters. And then we have NESCAM that I mentioned, but we have also Neosia Renewable that is deputed to the renewable energies, and other important companies that are all part of this big puzzle. We are more than 9,300 people, divided in more or less 6,300 employees plus 300 professionals. We are operating in 45 countries. This means that we have a look about what the world is asking. It is another added value because we are able to transmit to you, let's say, an overall picture about the business community in the world, from the east to the west and vice versa. Going on, you see that our footprint is more or less present in all the continents if we exclude Australia. So this is another important added value that we have in order to have in mind what kind of different cultures we are dealing with. I would like to stress this point because in a way it's also representing our culture, our DNA, our model to operate. What I mean? I mean that when we arrive in a country, we would like to extract as much as possible the value coming from the local content. Local content is, of course, the products that you can find, I mean the factory, the technology, but is also what is possible to have coming from people. So in this sense, you are part of the future talent of your country, and you are part of what we are using to call the local talent. In this sense, Maire Tecnimont is approaching the countries where it's based, giving priority to the local talent. It is very important. And this agreement with the Gupting University is based on this kind of aim, is based on this kind of approach. Going on with the presentation, you can look to this chart, but just to having the evidence of what I said before, so what I mentioned as a first cooperation in your big country, of course, the number of plants that we were able to building up in Russia. It's very important to mention that in 1995, we had the first two turnkey plants in Moscow, means that we were able to building up from scratch, from the engineering phase to the construction phase in a very distant country. On that time, you have to imagine no internet, no mail, just maybe fax and telex, and we were able to deliver important plans to our client. And then, of course, you can see all the important milestones of our history in this country. Going on, Alessia. Here, while the web will allow us to see the movie, because, of course, we have to dialogue with a lot of bytes to transmit, you will perceive as soon as the network will allow us to see what, in this case, Tecnimont was able to do in the 90s. So this to demonstrate that the link with your country was very strong since, let's say, 90s years, but also before, as we say. And please, let's see the movie. I don't know if we will hear anything, but at least we will see what does it represent. Okay, maybe it will be very nice and most probably one of our colleagues that will have the lessons offline, no, offline, yes, because we have to manage different web or not, will present to you again with the computer this video. However, the video was giving you just a synthetic idea of what was to design a petrochemical plant on that years. You saw most probably people that was designing by hands and not with computer and so on. So it was just to demonstrate our long history. Coming to us, of course, today we are proud to establish, to start with this chair with your prestigious university. But we would like also to stress that Mare Tecnimont Group boasts on a very long history of collaboration with leading university and technological partners, such as also, let's say, the university that I mentioned before, but also with the research centers and commercial partners. So in this sense, we intensified a lot our collaboration, both with the best Italian and foreign university, but also with the private research centers, in order to develop research projects, in order to exchange opinion and ideas, in order to support the growth of a very strong bridge between the academic and the industrial world. And this is very fruitful for both sides. For us, because we are the access to the so-called young talent, as we say before. So it's a way to facilitate the connection with the academic work, in the same time to facilitate, to support the integration of young people in a way to allow you to fly as much as possible in a very short time. This allowed also to at least contribute for a managerial imprint on your brain, or your approach. It's also a way to transmit to you the skills, the professionalism necessary, appropriate to the needs of the business arena, as I mentioned before. On the other part, is also a way to, let's say, increase the possibility to enlarge your links with companies throughout internships stage, and also to participate to some work sites. It's something that we experimented in Italy, but also, just for instance, in Azerbaijan. And so we would like to going on also with Guping University. Of course, as a business point of view, it's a way to scout the young talents, to support your training. Of course, also to identify and promote activities that allow the different training courses that are also linked and that are matching with the innovation and the development needs of the company. So it's really an osmotic approach that, according to us, is a win-win situation, supporting the acceleration of the transfer of technology and knowledge and skills between the two parts. So the synergies that we can see on the table, it's really the promotion of local employment, the economic employment, and also to accelerate and transfer the skill and resources. Especially these two parts are really the base of the pillar that we used to call in-country value. Means that we are giving a value to the talents of the country where we are operating. So in this sense, Russian Federation. So business, university, synergy can develop and support the in-country value. That is something that is also requested in a very strong way from the leadership of your country, but it's, honestly speaking, requested by the leadership of most of the countries where we are working. Here you can see what I mentioned as relations with the university. So for sure, Politecnico di Milano. Politecnico di Milano was also the university where Mr. Natta, Nobel Prize for Chemist, was professor, and Mr. Natta was a colleague of us. So we are proud to say that we are the, let's say, the nephews, the grandchildren of those pioneers that in the 60s years in Italy create and developed the future of chemical engineer. A campus biomedico is the university where I'm the honor to have the chair since 2011. La Sapienza is another university, public university in Rome. Baku Aiger Oil School is the university in Azerbaijan, that it's in a way the university that's creating the new talents in oil and gas sector. The Gupking, your university, we hope it will be one of our partners, and we are proud to be the partner of your university as well. Of course, we have many other Italian and foreign academic partners that are dialoguing with us. But again, in the unique frame that I mentioned before, in order to extract a win-win situation for our company, but also for you thinking to you as a unique entity, university, talent, business community in the future. Going on and going to explain a little bit something about the overview of the course. We designed with the fellow colleagues of your of Gupkin University 5 modules. So the first one is relating to the role of the EPC, engineering, procurement, construction in fuel and energy. So we will try to give you the basic types of contract that are used in EP construction. Mr. Andrea Bonacina will follow my introduction and will start with give you a frame about this. Of course, we will talk about the stages of project execution and going on, what is the link of the international EPC contracts considering the specific arena that is Russian Federation. Then we have another module that is referring to office management. Office management means get into the project office management and structure. So what does it mean in the current business, this kind of topic? And on the other part, the human resource management and the employee roles. In our sector, in our business, in our company, human factor is very, very important. And it's very, very important that the management team is able to manage these kind of topics carefully. Then we have a module considering capital structure. As you can imagine, nowadays, money, funds, finance, it's very important to build up a complex project. So working capital and current assets management, it's something that we have to deal with. The same with the current liabilities management. So having in mind what does it mean is very important. It's very important for you when we will approach the business community, the business arena. And the same is for the working capital management, the net working capital, and the related trade-off between profitability and risk. Any let's say project is linked to these two words, profitability and risk. Any company needs to know the relation between these two kinds of words, and as much you will be able to manage these two let's say arguments, topics, as much you will be successful in your career. Then, of course, logistics, it's very important. If you think how the pandemic situation affected the logistics, you can imagine how it's important to know the details, but also to know how to deliver equipment and how to deliver on time and on budget. If you think maybe I'm just going out from our business, let's think about Amazon. What what representing the pandemic situation for Amazon, representing that the owner became again the number one in Forbes ranking for his richness. But I think, I don't know in Russian Federation, but for sure in the West countries of Europe, you can, let's say, during the pandemic months, you could have everything in your home throughout this kind of way to deliver. This means that is changing the approach. And we have to think how this kind of change of mentality can be applied to complex projects as are the petrochemical or oil and gas one. In a way, we were look as Mare group to this kind of issue, especially leveraging on the digitalization, and in a certain way was our good vision that allowed us to maintain, despite the hard times coming from the pandemic issues, allowed us to survive. But in a way, it's obliged us to stress this kind of topic, because supply logistic, according to the types of contract, especially in a country as you are living, it's very important. If you think that a winter can affect dramatically the delivery of big equipment, so you have to manage logistics carefully, because more or less you have 2 windows during the year. And if you have to arrive in the eastern region of Amur, where we have a big project with, let's say, big items, you have to consider carefully the plan to deliver this kind of equipment. So logistics is really important in our sector. I would like to use the last 2 minutes that I have before to give the floor to Mr. Andrea Bonacina, considering one of the most important values for Maire Tecnimo Group, that is the in-country value. In-country value, as I mentioned before, is strictly related to the local content. It's strictly related to the DNA and the culture of the country where we are working. So for us, it's really, really important. It's something that put in contact our DNA, that is represented by our mottos. Maybe Alessia can share again the last page of the presentation. Our DNA with the culture, the local content, the attitude of the country where we are proud to work. So in this sense, I can say that in one, it's not important, Alessia, if it's a problem to in one of our motto, you see, be adaptive. It means that we are proud to say in any country where we are, let's say, ready to listen and try to understand the culture. That means the possibility to dialogue with the people. We are also resilient, so we have the possibility to resist time to time, also to understand the different culture. And of course, there are other mottos, but these 2 are the most important to stress the importance of the in-country value for Maire Tecnimo Group. So for now, I stop my introduction. We will be in contact, and we will be for sure again together in the next future, hopefully direct at the university in case it's possible, it will possible. Just other few words telling that today you will have the lesson of Mr. Bonacina, but in the next future, according to our program, some of my colleagues will be with you. Some of them that are based with me in Moscow office will try to come direct to university. So we will try to do our best to be in contact to you and to, let's say, extend our gratitude in a way to be part of this program, and in another to extend and to spread around our, let's say, knowledge in a sort of knowledge sharing with you about our business. Thank you very much. Nice to meet you also in this virtual way.
Many thanks, Mr. Bardak. We were glad to hear you and see you. Thank you.
Thank you.
Okay, you will see this nice guy from London, I guess, because I recognize in his house in London. So pandemic issue is also oblige us to be, let's say, connected around the world. So Andrea is one of my, let's say, fellow colleagues. Andrea, please, the floor is yours.
Grazie, Gian. Hi, everybody. Yes, I'm in London, correct, and I am stuck here because of COVID, as many other colleagues, and I guess your situation is not any different. But slowly things are getting better. So let's see. Anyhow, I really enjoyed hearing the introduction from Gianni, because it gives depth on what we are doing and the extent of what we are able to achieve as an organization, working around the world and being able to experience a lot of different environments, and in particular the Russian environment, which is one of our main and strategic markets. So if we can start with the presentation, Georgia, please. When I was asked by Gianni and Alessia to prepare a certain number of lessons that we will have from now until Friday evening, I immediately tried to understand what could be interesting to you as a perspective. And in my working experience, I had a period when I worked as a consultant, and the difficult part is always to understand what is listening might be interested into. And I think that it's more effective to talk about your own experience rather than to talk about theory. And this is how we prepared this course, at least these first 3 lessons, with a very hands-on approach, a very pragmatic approach, and everything is described from the contractor's point of view. So we are not clients, we are not subcontractors, we are not suppliers, we are contractors. And the business of the general contractor in the EPC for the main management of industrial plants is very specific, and requires a set of skills that were already anticipated in part from Gianni in his presentation, but that are all required to be able to manage contractual complex situations. So when we talk about EPC contracting and the legal implications, and this is the big premise to everything we are about to say, don't focus on the wording of the contract only. It's the bigger picture, it's the bigger context. So Tecnimont, as Gianni anticipated, is Maire Tecnimont. Sorry, it's a group that operates in all possible fields of industrial plants. So we have our DNA in petrochemicals, but we have huge experience in fertilizers, including in Russia, oil and gas refining, including in Russia. Power, we just completed a major power plant in Central America, and we are pioneers as well of new fields, new areas, which are the green chemistry and the renewable. that will constitute for sure the future of our industry. And we are there, and we are developing know-how and management experience on these aspects as well. We have some key messages that we apply every day. So the be adaptive that Gianni was mentioning before is exactly the core of our business, because we work in different countries in an international environment, and that of course has an impact on how we have to adapt to different situations and to the peculiarities of each country. We work with new technologies. The renewables and green chemistry is an example, but also we do known projects with new skills. And so we are introducing technology, digitalization, different ways of financing projects. We are a business of managing people. We work in an extremely multicultural environment. And the contractors, general contractors' role is by definition that of managing complexity, and that also, and Gianni is the best representative in our organization to that extent. We generate a growth that is larger than our organization. We in Russia only, we have established a long-standing relationship with our clients, with subcontractors, with suppliers, with freight forwarders. So through our work, we are able to generate something that is bigger than the project itself. Before Gianni showed the extent of our business and in which countries we operate, our headquarters is in Milano. We have an headquarters in Rome as well. The department I represent with the other colleagues today is the contract and subcontract management department. I always focus on people and diversity for the simple reason that I believe that we are good as long as we are able to take the contribution from everybody. And our department was developed and structured in a very horizontal manner rather than a pyramid. It's more about different skills, different set of knowledge that it's all needed to carry out the complexity and to manage the complexity I was describing. And that will be the focus of today's lesson. So short introduction, even in this virtual environment that makes it let's say more difficult because we cannot see each other's face, and so it would have been way better to be there in person. Anyhow, I grew up in Tecnimont. Tecnimont is one of the companies of the Maire Tecnimont Group. Is the most important company, and I studied law, so I'm a lawyer. But then I immediately started working on the EPC business, and I moved immediately to site. So the first 5-6 years of my career, I mostly spent my time working on projects abroad. So not in the office, but in the field. And that gave me a very pragmatic way of approaching matters. Then I lived in South America for a short period, and then 3 years, so not too short, but compared to my overall life is not too much. I then moved to the UK, where I had a working experience here, and I came back to Tecnimont in 2016, working now at group level, and I'm the vice president of the contract and subcontract management department. Tomorrow, today she's not connected because she's traveling, but tomorrow Nadia Berroyel, head of contract management at group, as part of the department. She will be talking about contract management in her own experience. She has a completely different background from mine. She has an economics background. She worked in Sonatrach in Algeria, and then she moved to the UK, where she grew as a consultant. and in different fields, including our field. And then she joined Tecnimont at the very beginning of my new adventure, and she's one of the top managers of our department. We will also have tomorrow Luigi Di Paola, that is, I believe, connected now today.
Yes, I'm here.
Ciao, Luigi. Luigi is a lawyer, and he worked for the most important law firm in Italy, Bonelli, Rede Pappalardo, for many years, with Professor Crivellaro, that is one of the eminences of Italian law. And on top of that, Luigi participated to many arbitrations, and he then moved to ENI to start to have an experience in our field, and then he joined Tecnimont in 2015, and so he also has a long-standing experience of industrial plants, and he will be talking tomorrow, as Georgia will say later, about specific legal aspects. Today, Luca Sommariva will work with me in presenting what is a contract and what is the characterization of a contract in our business. Luca is also a lawyer, and he joined a couple of years ago our organization. But before that, most notably, he was a partner of Kellen Gates, which is, you probably know, the most important law firm in construction law worldwide. Then Luca will have a chance to introduce himself. Paola Fancoli will talk together with Egle Ferrari on Friday in the last lesson about Russia. Both Paola and Egle have extensive experience in Russia, and they participated to many negotiations together with me and other colleagues in the past years with key strategic clients we have in Russia. Paola is an engineer. She joined our department in 2016. And she went straight to site in United States, and then when she moved back, she started working on the most important project ever awarded to Tecnimont from Nipigas, the Amurski project. And she's still working as a head of the integrated project division as far as contract management is concerned. Egle has a legal background, and she has extensive experience in negotiating, as I said, with Russian organizations, and she's a part of the claim department together with Luigi and Luca. And finally, we have Giorgia Chinaglia. She has a humanistic background, and she's supporting the department in preparing strategic presentations during our negotiations. And so she's involved in the whole loop on how to deliver a message, and how you deliver a message is a key aspect of our work. So again, it's not just the wording of the contract that matters when you operate in the EPC business, but it's also how you deliver the message and what is the key selling point you want to deliver. And in that, Georgia is supporting us, and she also prepared the presentations that we will use as a guideline to our lessons. And so I will ask now Georgia, after this image about that I believe well represents the way we work. So it's not a pyramid, it's an organization made of different people with different background that all contribute to the final result. So if you can please, Georgia, explain how the 4 lessons in the 3 days are structured, and then we can start.
Okay, thank you, Andrea. As already said by Andrea, we prepare this course from the contractor's point of view. We will go through different topics, technical, engineering, and legal topics with colleagues who have relevant background. But before we begin, we believe that it is paramount to give a very brief overview of the context in which we operate. understanding which is our job, our role, and where we operate. And the duration of the course will be 3 days. Day 1, the lesson will be focused on the role of the contractor in the execution of the engineering and construction of the industrial plants. And Luca Sommariva, lawyer by profession and claim manager, head of department at KT, will be the speaker. Day 2 is divided into 2 different sections. First one will be strictly focused on legal aspects, namely types of contracts, prepared by Luigi Di Paola, who is lawyer by profession and head of claim management group in Maire Tecnimont. The second part of this lesson will discuss the application of the theory in practical purposes, especially during project execution. And Nadia Berroyel, who is group head of contract management, will give us this perspective and explain the contract manager's role. Last lesson will focus on Russia and how Maire Tecnimont approaches this business scenario. Paola Fancoli and Egle Ferrari will explain the role of a foreign contractor in Russia and the various criticalities encountered.
Grazie mille, Giorgia. And I think we can start with our work. One point about the organization: we have left at the end of each day some space for question and answers, if any. So if you can please note down your observations, we can then discuss them in the end, as I believe that it gives us more time to address all the aspects and maybe answering your questions during the evolution of the lesson. Luca.
Good afternoon, everybody. Thank you, Andrea, for the introduction, and Giorgia. It's a pleasure and an honor to be with you today. I don't want to spend too much time in introducing myself. You will find a short bios in the slides. What I would like to point out is that after having spent something like 20 years as a lawyer, I finally joined the group as a claim manager. And don't get misled by the job title. The main target of our job is not to claim itself, but to prepare legitimate requests that we make sure are properly prepared and properly supported, and are properly separated by the wishful thinking that sometime our projects might have. So it's a matter of way of presenting our request. But this is interesting also for another reason, which is mainly because after having spent a lot of time in negotiating contracts or assisting clients in international arbitrations, now I'm working on a different level, and we basically assist our projects throughout the life of the project in preparing this kind of requests, which is a quite unique point of view, allowing us, me and my team, to see things from a very practical point of view. And this is something that I would like to transfer you today, this kind of practical approach, even if we are going to talk about legal stuffs. There is another promise that I would like to make you today, and this is another kind of introduction, not of myself, but of our lesson today. And this starts with a kind of joke back of my early in the days when I started dealing with international construction projects. I came across a very experienced international arbitrator, a mediator, back in time, and he told me, well, you are a lawyer, that's interesting. You know what it's the difference between a lawyer and an engineer? And I was prepared to give a number of answers, but he said, well, the difference is that a lawyer knows, is aware that it's just a lawyer. And I quickly realized a few things. The first, this is a kind of recurrent joke in our industry. And the second one is that it's tremendously true. All the engineers that I've been working with since then truly believe that they can deal with legal issues. And I also realized that this is a natural effect, a natural side of our industry. Again, for a number of reasons, the most important of which is that basically there is no project without a contract. But I should say actually that there is no project without a number of contracts. International construction projects, but domestic projects as well, have a highly sophisticated network of contracts. So I'm not sure how many lawyers there are hiding among you, but I have the feeling that the vast majority of you do not have a legal background. So my task today is to provide you at least a sense of some of the key principles governing our contracts and our projects. But of course, I'm going to talk to you for just 1 hour. I cannot provide you much more than a sense. So when I was preparing this lesson and these slides, I told to myself, well, you know what, rather than, and I'm now quoting Bruce Springsteen, you know, you can't start a fire without a spark. Without trying to be the fire, without trying to provide you all these key principles and legal frameworks, let's try to be the spark. And hopefully, and presumably, my colleagues in the next in coming days will probably do the same. We will try to be your spark. What do I mean? I mean that rather than providing you a set of information that you are supposed to keep in mind, what I would like to do today, and this is my kind of promise, is to wake up your curiosity and make you more aware of what's behind what I'm going to tell you. So it's not a matter of what I'm telling you, but it's more a matter of approach. So the invitation that I'm making is try to follow this lesson in a very active way, and please do not hesitate to share your experience or ask questions or interrupt me if you like. The more interactive it is, the more useful it is. But again, the idea is that you can at least grasp the practical approach and the idea of that there is always a reason for virtually everything I'm going to tell you. Having said that,
I have one
sure.
quick comment, Luca. As we agreed during these days, we want the discussion to be dynamic, so not to be a lesson per se, but something that is more about considerations amongst friends on what might be the troubles we are confronted with when we carry out our daily tasks. So when we started the drafting this part of the course, the real question we asked ourselves it's let's start from the basics before jumping into the more technical aspects that will be discussed in part of the presentations today, tomorrow, and on Friday. Let's also ask ourselves basic questions, like the starting slide of this lesson. So what is a contract? Rather than discussing about an EPC contract in the execution of industrial plants, let's define what a contract is. And always remember, and I reiterate that because I like to repeat myself, we have to consider that the contract we talk about daily in our business is not the wording of the single clause only. It's something way bigger. And we will try to address this complexity as much as we can with the sparks that Luca was anticipating, but also considering that is a legal aspect, it's a technical aspect, is a relationship aspect, and everything together makes economical, everything together makes it complex. And our work is not to be legal experts. Our work is to be aware of the complexity and ready to manage the complexity. So please, Luca.
Absolutely right. And the first way to be aware of the complexity is to avoid to think that something is obvious, because in our industry, nothing is obvious. And we can start with a practical example. Let's have this definition of contract. I assume that every one of you knows, or at least thinks to know, what a contract is. And the definition is pretty simple. A contract is an enforceable economic agreement that two or more parties want to enter into to define their respective rights and duties and allocate the risk. It's fairly simple, fairly clear, but again, let's try to take away an approach from this lesson rather than simple notions. Is it really so obvious? For example, define their respective rights and duties. Why is that? There is a legal system in every country. The law provides for duties and rights. Why should I know? Should I need a contract? Answer, again, it's pretty simple, because the contract is the vehicle to transfer those general rights and duties into the single transaction. But the single transaction and its contract remain to some extent linked to the general legal system. And this creates an interaction between the contract and the governing legal system, which you should be aware of and which we are going to explore in a few slides. So this is for the first aspect. Second point, to allocate the risk. No, Giorgia, please remain on the previous. Allocate the risk. In our industry especially, contract is the tool to allocate the risk. Our projects usually are based on 2/3 years time framework, and as you can imagine, or as you can already know, a number of things are going to happen in those 2 or 3 years. So there will be opportunities and there will be risk. Contract is not only the place where the parties agree on duties and rights, but it is also the tool that they use to allocate this risk. And this is a key role in our industry that contracts play. Clauses like, for example, force majeure or change in law are key clauses in our contracts, because these are typical risks every project faces, and which the parties, starting from day one, need and want to allocate. I can already tell you from a practical point of view that over the years in our industry, certain risks have come to be a typical contractor risk or typical client risk. The change in law, for example, is a typical client risk. Why is that? Because if we are talking of international construction projects, the classical scheme is that there is a foreign contractor coming in one country to build something for domestic clients. And the foreign contractor can, of course, manage a certain risk, typically the risk strictly related to the project, but is not in control of any risk related to the country where he's going to build the project. So this kind of risk is usually lies with the clients. So again, rather than the information themselves, be aware that contracts are a tool to allocate the risk. So you might want to be very well aware of those provisions in the contract allocating risk. Some other ideas around this definition. Contract generally is an enforceable. Why is enforceable? Again, a matter of approach. When you are dealing with legal documents, legal definitions, legal contracts, legal letters, be aware that in most cases, every single word counts. Every single word has a specific meaning. Of course, if it's drafted by a lawyer, not by an engineer. So we are saying that's enforceable. What does it mean? It means that if one party breaches the agreement, and the agreement is a contract, there is a liability, and the other party can Georgia. Okay, can remain. Can go to the court of law to seek compensation for damages. So it's enforceable. It's an economic agreement. This is another key concept. Why is economic? Because there are a number of agreements that we make every day, but of course not all of them are contracts. If Andrea and myself agree to meet at 4 p.m. this afternoon, and I do not show up, and I stand him up, he cannot seek compensation for damages because I breached the agreement, but I didn't breach a contract. So every time you come across an agreement, you might want to check whether it's an agreement on something of economic, because in this case, it's probably a contract. And if it's a contract, there are some legal consequences. 2 or more parties. It's impossible to have a contract with myself. Every year in September, I promised myself to go on diet, but this is not a contract, of course. So 2 parties are needed, but sometimes you have a multilateral contract when more than 2 parties are involved. Okay, Georgia, you can. So here you have every single concept highlighted: enforceable, economic agreement. Want, this is something that I was missing. Want means that there must be a free will. I cannot be forced to enter into an agreement. This is a very tricky concept in our sector, because in many occasions you are actually forced to enter into an agreement because you do not have a true alternative, from an economical point of view, from a market point of view. We operate in the oil and gas sector. In the oil and gas, clients are few, so your choices are limited, and this is a feature that reflects in when you're negotiating a contract, because you cannot argue that much with a client because there aren't plenty of them. So the definition says that you have to want to enter into an agreement, but sometimes it's a slippery concept. However, it makes a huge difference on whether you are in civil law jurisdiction or in a common law jurisdiction. So keep in mind this point, and we will get back on it in a few moments. Georgia, please. Now, if I ask you, is it more frequent to have a written agreement or an oral agreement? You probably would answer, it's a written agreement. This is not true. Statistically, the vast majority of agreements are executed orally. And why is that? Simply because from a practical point of view, you cannot ask the parties to sign an agreement every time a contract is concluded. A very simple example, if you enter into a restaurant and you order a dinner, you are actually entering into an agreement, into a contract, because you are buying your food, and of course it will make you liable for paying the price. If you do not do that, you will be exposed to a lawsuit. So the restaurant can file a suit in court and have you ordered to pay the price. So it's a contract, but it's not written, it's oral. Again, from a practical point of view, it will be impossible to have a written agreement. So having clarified that, you should be now aware that most of the contracts are stipulated orally. Back to our industry, in our business, we have highly sophisticated contracts which are always written. But as we will see in our lesson, contracts are alive. They change over the life of the project, and they change based on the interaction between the parties, between the contractor and the client, between the contractor and the subcontractors or the vendors or whatever. So what happens? It happens that you can imagine you are in the middle of a construction site, no lawyers around, they're all engineers or workers, and at a certain moment, the client representatives say, well, you know what, I would like to have this built in this way rather than the other. And the contractor says, okay, fine with me, I will do that. Is this a contract? Yes, it is. The parties have signed an agreement. It's an economical obligation, and it's oral, so it's fine. Now, if you mix the complexity and the sophistication of highly complex international construction projects with this possibility to conclude contracts orally in the middle of nowhere, you can appreciate how easy is to amend a contract under certain circumstances, and how complex and how vital is to track the life of the contracts. So keep in mind that contracts can be stipulated or amended orally, and keep in mind that it can be a hell of a problem in a construction project. This point can be a hell of a problem. It's not always like that. We all experienced at some moment in time to have signed a contract, which is in writing in a simple form. If you, for example, stipulate an insurance cover, or if you go to your bank to open a bank account, you will sign a certain number of pages, and this is a simple contract in the straightforward sense that we all have in mind. But there are, just to complete the picture in your mind, there are also other more sophisticated form, more burdensome forms that are sometimes requested by the different jurisdictions. For example, if you sell or buy something very important like an apartment. Why is that? Again, keep in mind this approach. Why is that? What's behind? Keep asking questions to yourself. Do not never stop at the surface, okay? Because only in this way you will grasp the overall sense of a set of rules. So why is that? Because the more burdensome form to stipulate a contract is a way to make you aware. If you have to show up before a public notary to sell your house, it's because the system wants you to be fully aware, fully informed of what you are doing, what you're going to do. The system doesn't want you to sell your house by mistake, or simply because you were talking to a friend over a coffee and say, okay, you know what, I'm sick and tired of my place, I want to sell it. And your friend says, okay, I offer you $1, and they say, okay, that's deal done. It cannot work like that. Houses, pieces of land, and these kind of things cannot be transferred over a coffee. Because it would be a nightmare to track the property of these valuable items. Georgia, please. So here you have a summary of what just I've said. As a matter of awareness, keep in mind that you stipulate a number of contracts every single day, even if you are not aware of this. That's fine. This is why oral contracts are allowed. Oral or de facto contracts are allowed. But keep in mind, back to our industry, that it can be very tricky to have this kind of approach in our projects. Now, a few moments ago, I touched on a point. I told you that the contract is a way to transfer certain general principles to a single transaction. And I also told you that the contract is born and remains linked to a legal system. Now, what I really find fascinating in our practice is that we do international construction projects. So we are an Italian contractor working virtually in any country in the world. And most of our contracts are governed by English law. So, for example, in Russia, we have a certain number of projects in Russia. Most of them are governed by English law. So we are an Italian contractor working for a Russian client in Russia with a contract which is governed by English law, which makes paramount to discuss what are the main legal systems that you can find around the world. Georgia, please.
I have one quick comment, Luca,
sure.
And it's strictly related to what you just said. Everything we are talking about, it's not irrelevant in that every slide is prepared thinking of what are the implications in our business. So for the students, I think it's important to ask themselves all the time. So this is an invitation I'm making. Why is this interesting to me? And there is a reason. Also, this slide Luca will discuss about. It's something where we are dealing with on a daily basis. We are dealing with different legislation. We will discuss about the peculiarities of Russia in today's time. But even if you are Russian, you are going to work for a Russian organization, and you will be probably working in Russia. You will be confronted with international contractors that have to experience this complexity. And if you understand the complexity they are experiencing, you will be a better client. You will be a better subcontractor because you will understand what to expect and how to manage the expectations. Please, Luca.
Thank you, Andrea. Yes, everything we are talking about come from practical experience. Absolutely true. And even if most of us are quite experts and have a certain amount of years of experience, and believe me, we keep learning every day, which is another factor making this business and this industry so fascinating. There are a mix of things. Talking of laws, legal principles, you cannot deal with a certain law without dealing with the culture and the history of the country that you are dealing with. Because of course, the lawmaker has its own history and its basic key principles and long-term targets. So it's really challenging to deal with a foreign law or a foreign legal system without being aware of what are the principles, customs, the history of a country. So what I'm going to say might sound like an oversimplification and might sound like a contradiction of what I've just said, but it's not true. I'm going to explain you in a few moments. Let's say that, generally speaking, there are these three main legal systems: the civil law, common law, and Sharia. Georgia, could you please show the next slide? Okay, in this slide, we are presenting you the geographical distribution of these three systems. And you can see that, not surprisingly, the Sharia is quite limited to the Middle East and / North Africa area, whilst the common law, which was born in the UK, is spread over the years also to the US, Canada, Australia, New Zealand, and India, and some countries in Africa. Again, talking of the mixing between the laws and the history, the reason is quite self-explaining. You don't need me to explain you that all those countries which have adopted the common law system are former UK colonies. So the UK exported its own legal system to the colonies, and they stick to that. The same applies to civil law countries. I can tell you that the modern civil law system, as we know it today, was born, or at least is in strong debt to Napoleon. So Napoleon drafted the French Civil Code back in time, and a number of countries adopted and adapted that code to their own system. Being an Italian lawyer, I can tell you that the similarities between the Italian Civil Code and the French Code are really surprising. What does it mean in our system, in our industry? It means that when you are a civil law-based contractor and you are working abroad in another civil law country, you can be quite comfortable that you are going to face the basic principles and an overall structure which is quite close to your own one. This is tremendously helpful in our industry because, you can imagine, makes everything easier. It doesn't mean that you don't need a legal consultant, a local consultant, sorry, to walk you through the local rules, especially the highly detailed ones, but the overall structure will be pretty known to you since the very first day. Okay, we can move to the next slide. Leaving the Sharia aside, mostly because I'm not familiar with that system and it's quite unique, I would like to present you the main differences between the civil law system and the common law system. Again, from a practical point of view, and keep in mind our industry first off. So, Georgia, please. And we of course will focus on private law, so setting aside criminal law, constitutional law, administrative law, and so on. The first key point is that private law is codified. As I told you before, this is due to Napoleon, which decided to collect all the rules that were enacted that far in a single body of laws, which is the civil code. The civil code does not stand alone. Generally speaking, in every country, it's quite difficult to change the civil code because it would be a mess to change it every day. So what happens is that the civil code remains as it is, generally speaking. It's changed every now and then, but as a rule, it remains as it is. But of course, the society, the business, the market evolve over time. So the lawmaker needs to adapt the set of rules and the legal system to the new need of the society. And this is made with the statutory laws, which integrate the code. So when you are, and this is something that plays a very important role in our projects, because a certain part of our duties and rights are governed by the code, the really basic ones, but there are a number of other rules stepping in to regulate a number of highly technical aspects of the project. The height of a chimney, for example, is not to be found in the code, in the civil code. It will be found in a specific law somewhere else. We will see in a few moments what these topics generally are, but keep in mind that your contract is linked and remains linked to a legal system. Keep in mind that this legal system in the civil law countries has its own focus and center of gravity in the civil code. But also keep in mind that around the civil code, a number of other issues will be regulated by ad hoc statutory provisions. Another level of complexity is that all these rules are overridden by some key principles. I'm listed the good faith, for example, or the consistency, or the principle whereby a contract drafted by one party must be interpreted in case of doubt against that party, which is the contra preferentem principle. Good faith plays an important role in civil law jurisdiction, and this is something that you might want to keep in mind again. Why is that? Because from a contractor's point of view, usually contracts are very stern and very I would say merciless, but let's say very tough against the contractor, because they leave very limited room for the contractor to claim whatever he wants to claim. The reason is that, of course, contracts are mainly drafted by clients, so it's difficult. Sometimes one of the arguments that we invoke in our discussion with the client is that, okay, the contract says this, but you cannot apply this provision as it is, because it would be a bad faith approach. Of course, we do that in civil law countries because we know that the good faith is an overriding principle. There is always a provision in the codes saying that the parties in applying the contract must obey to the good faith principle. So if sticking to the grammatical meaning of a provisions turns out to be a bad faith conduct, you can say, no, okay, you have to walk away from the contract in relation to this specific point and stick to the good faith principle. So again, the takeaway here is you have a contract in your hands. This contract, of course, will apply, but keep in mind that if you are in a civil law country, the contract must be applied and interpreted in compliance with some overriding principles, the first of which being the good faith. And this is, Andrea, please.
Sì, no, Luca, I just wanted to add an additional perspective. You said before that the majority of contracts we enter into with our clients in Russia are ruled by common law, English law. And this is something that should be observed in more detail, because you have one contractor with an Italian background in this case, and with a civil law system. So when we grow up in our society, we are used to have something that is written that protects us irrespective of how detailed our agreements are. And we negotiate with a counterparty, in this case Russian, that is used pretty much to the same thing. We can enter into a contract, a written contract, without writing too much, because there are already many provisions that are covered by the codes. And then you demand to a different kind of jurisdiction that is based on totally different principles, as you will now describe, which might lead to some schizophrenic interpretation, because the intention of the parties that is fundamental in our legislation, the intention of the party that it is fundamental in Russian legislation, is not basically considered in a common law legislation. Right. And so something that we take for granted is not at all when you decide to have the contract then ruled in accordance with the laws of England and Wales.
Absolutely. And the picture gets even more complicated when you add the subcontractors. Local subcontractors or foreign local subcontractors coming from another jurisdiction ever still. So Chinese, for example. So it's really challenging and fascinating as well.
And you may just describe quickly the common law. Maybe then we can have a break, Luca, because
sure. Yeah, absolutely. Common law for a civil lawyer, a civil law lawyer, can be really frustrating for the reason that Andrea just touched on. It's totally the opposite. The main difference is that, as you probably already know, their system is based on the judicial decisions, on the case law, rather than civil codes and a certain number of statutes. Their constitution, for example, is not written. It exists, but it is not written. For me, as an Italian lawyer, having a constitution which is not written is something unbelievable, but this is the reality, and it works. Coming to our industry, the main difference is that contract is king. Contract is king is an old saying, which is a kind of mantra for every British lawyer or judge. What does it mean? It means that, well, I will use the words of a judge in one very famous case. Contract is king means you discussed it, you liked it, you signed it, you keep it. And there is no room under English law, there is no room for interpretation if the literal and grammatical meaning is clear. It makes no difference whether the provision makes no sense from a business point of view. It makes no sense, it makes no difference if it's clear that the parties wanted something different when they negotiated that contract, and makes no difference whether the contractor in this case had or had not the real power to negotiate that provision. And we go back to the want that we touched at the very beginning. So, and this also explains why English law is so common in our industry, because the English law is very keen on protecting the contract. And the contract, remember, are drafted by clients. So having a powerful client proposing a very strong draft of contract governed by English law is the best way to, I would say, to push the contractor in a corner, but let's say to have the maximum stability of the contract that you can imagine.
There's one consideration on this which I would like to draw. It's true that it protects the client the most, but it's also true that if we go back to the image of not on the slides, but to the image of sustainability, for a project to be successful, and this will be observed tomorrow when Nadia Berwayel will make her speech. For a project to be successful, we must maintain a certain equilibrium between the parties. So when you have an unbalanced contract where the client is having no risks and the contractor is having all the risks, in reality you end up having a worse project, and a worse project is a damage to the client. And so the client, by protecting themselves too much, are generating a damage to themselves. The paradox is there. So we believe that, based on our experience, successful projects are the projects where the parties have a lot of flexibility and adapt themselves to the needs that arise down the way. When you have rigid approaches, and we just had a very difficult experience in the Middle East with a client that was extremely rigid in any kind of interpretation, it becomes very difficult, because then you don't allow the contractor to take risks, you don't allow the contractor to take initiative, the contractor becomes very strict with the subcontractors, and it's just a negative circle that it's self-alimented. So it's not a matter of common law or civil law, it's a matter of flexibility within the legal implications.
The golden rule says that the risk should lie with the party who is in the best position to deal with it. but sadly this is not always applied. There is an historical reason for that, starting from the 80s, when the banks started to finance the projects and the project financing was born. Banks, of course, are risk adverse, so they totally refused this allocation of risk, and they wanted to shift all the risk on the contractors. And since then, we face this very unbalanced and very risk allocation. Okay, time for the break, I assume. I will just quickly close this first part with the next slide, which is a quick summary of all the parties involved. Simply because when we discuss the complexity that can be generated by the mix of legal systems involved in a specific project, you have to keep in mind that there are a number of players in every project, and each of them is familiar with, or could be familiar with, a totally different legal system than the others. Okay.
The role of the contractor is like that of a director. So it's important that this is cast in stone. We are not bound by contracts, but we are bound by relationships. These relationships are then managed through contracts, but each one of these interactions has to be dealt with a very in a very different way, and with very different skills. And this is also why, as a department, we are organized as we are, because when we discuss about financing, it's one problem. When we discuss about subcontracting, is another kind of problem, and so forth. So we shall have a break, 10 minutes, and then we
resume.
We start in 10 minutes time exactly.
Okay, so we already touched on this slide, Giorgio. We can. And if you agree, since there are a few questions popping up, maybe we can accelerate a little bit so that we can have a proper time for Q&As. Now, one of the features of our contracts that I have to say, especially engineers, but lawyers too, sometimes tend to forget, is that the contract is alive. This is a very simple concept, and yet it's not given the proper attention. Especially engineers, our members of the project team, they are fully aware that design, for example, is alive, that the design is basically closed when the project is finished. I am exaggerating a little bit, of course, but design evolves over the project. Quantities, the program, of course. So all the key documents in a project evolve throughout the life of the project. Contract is no exception. The same applies to the contracts. As I said before, this can happen in a number of ways and in a number of occasions. Typically, something happens whereby the parties need to amend the contract, and so they enter into an amendment, which is a kind of a contract within the contract. Because a change is agreed, some additional works are agreed, so the parties enter into a different agreement stating that pursuant to this amendment, a contractor is required to do this and that, and as a consequence is entitled to an additional share of price and or additional time. But as I was saying before, this can also happen in different ways, by means, for example, of oral agreements. Oral agreements, and someone was asking how can this actually happen. or can I prove that I did everything right? Well, this is a hell of a question, and this is one of our headaches during our job. In most of the time.
Just sorry, Luca. Just
sure.
An example to give some practical and explanation. When you are at site, construction works, a superintendent, a construction manager giving instruction to the subcontractor to do certain things. There are thousands of these kind of instructions that are given. Of course, there are also formalities that are in theory required under the contract, but the colleagues working at site for construction are not lawyers and are not necessarily even aware of what the contract has stated. And another consideration linked to this is that the negotiation of the contract is made by lawyers, and it takes a lot of time. And then when the contract is awarded and execution starts, you have 3-4 years of interactions between project teams that exchange emails, write minutes of meeting, have a daily interaction, say a lot of things without exactly remembering all the implications that the contract might have. And this piles up for months, up to the end, when if there is a conflict, the lawyers come again into the picture, and you discover that many things that have been said or that have been told shouldn't have been said or told. So beware that it's a beast well alive and kicking.
Absolutely. And as a matter of fact, the mantra of every claim manager is, with the words of another judge from another famous case, records. At the end of the project, you should end up with a pile of records for everything happened and everything was said. One of our job is that whenever something is agreed at site, we always suggest our project teams to immediately record that instruction or that agreement somewhere, somehow, namely in a minute of meeting or in a following email. Dear client, as agreed this morning at site, I'm going to do this as per your request. I will let you know in due course the impacts in terms of time and money, if any. So this
is again, it's probably for the people listening to us, it's normal, because in Russia, same as in other countries, there is a strong education towards formality. So the things in written, it's something that, on my experience, the Russian friends and colleagues I'm dealing with are used to. But rest assured that if you come to Italy, or if you go even farther in South America, it's another ball game. And so it's important that you understand that again, Russian specialists working in this business, that it's not so obvious. And for some people, it's very difficult to keep trace of things. And so when the problems hit the fan, I want to be polite, if records are not consistent, are not prepared in time, are not notified according to the contract, are not followed up in accordance with the contract, you start having problems, because parties start having frictions based on different understandings. And the role of the contract manager, it's to facilitate that clarity is in place, not uncertainty. So if you ask me to do something, I have to be sure that I do that something based on what the contract provides for, and not based on what I would like to do.
Yep. Thank you, Andrea. As promised, we try to speed up a little bit. So, Georgia.
And we aren't.
Yeah, exactly. Yeah. Because the problem is that we love what we do, so we could spend the whole day talking about it. another point that I would like to touch on is the applicable law versus the local law. Okay, the starting point is, as written in the slides, the parties are free to choose whatever laws they prefer to govern the contract. Okay, now based on our experience, the two most commonly chosen ones are the English law and the local law. The English law has or comes with some very specific upsides. The first one is that protects the contract, as I said before, and the second is very sophisticated from a construction point of view. This because the UK government has been always very proactive in trying to understand how the legal framework for the construction industry can be improved. They have always worked and keep working with major law firms, reputable law professors, experts from the field. They are constantly trying to improve the whole legal framework, and they are quite successful in that, I have to say. And this can be felt at international level as well. So English law for a construction project can be really good. Nevertheless, sometimes some clients are state entity or state-controlled companies, and they are required by local law to apply the local law. So they are prevented from choosing a different law. This, for example, based on my experience, tends to happen and tends to be the case in Eastern Europe. I'm thinking of Romania and Poland, but it's mainly linked to the ownership of the client company. One key point that I would like to point out is that usually the law governing the main contract is chosen by the by the client, but contractor is in charge of choosing the law governing all the other contracts that is going to stipulate with subcontractors and vendors. Now, what we record is that sometimes contractors tend to try or are tempted to change the governing law throughout the supply chain, applying its own law, or, which is, in my opinion, a mistake, choosing a totally different law, like the Swiss law, because the Swiss law is always perceived as a neutral law. Now, Switzerland can be neutral, or could have been neutral during the Second World War, but its law it's nothing to do with neutrality. It's a law like everyone else, every other else. So there is no really any advantage in choosing the Swiss law or a totally different law. My advice is that, at least for the key subcontracts or the key purchase orders, the same law that you have in the main contract should be applied, that should be chosen. This in order to guarantee as much as possible a back-to-back situation of the mutual rights and duties. Georgia, please.
There is one key example on what we are discussing, Luca. That is, I believe, or at least based on my direct experience, is the transfer of ownership. We, as an organization, for instance, when we purchase in Italy from Italian suppliers, the procurement department usually uses Italian law. And the transfer of title, if nothing is said by the parties, it's ruled by the civil code. And there is a exact moment in time when the ownership of the goods is transferred to us, and then based on the main contract we have with the client is transferred to the client. Now, if you have, if you don't use this back-to-back, as is improperly called, but it's a common definition, back-to-back with suppliers and subcontractors, you run the risk of having some misalignment, substantial ones,
especially, I'm sorry, Andrea, to interrupt, especially if you are choosing two legal systems, one of which is a common law system and the other is a civil law system.
Exactly. So you might be obliged in front of the client to transfer the title at very early stages, and maybe you entered a contract where you are not the owner yet of the good, or vice versa. So you might be exposed to a greater risk because you are owner of the goods, and maybe you have not transferred that ownership to the client yet, and there are legal implications with that, and also legal risks, or the other way around, that you might have committed on something that you are unable to provide under the contract. So you are, without knowing, in breach.
Absolutely.
And so these aspects are all to be examined and evaluated with extreme attention when drafting contracts or when deciding what contractual strategy to adopt on projects.
Yeah, not to mention because we are now focusing on the governing law, but another key point is the alternative, the dispute resolution clause, because if you are going to fight with your client before an arbitral tribunal and your supplier, which supplied the equipment that proved failing and put you in trouble with your clients, and in the purchase order you do not have the arbitral clause. I'm sorry, an arbitration clause, but you have to fight before a state court. It's going to be a real mess, especially for main contractors, which in most cases end up in the middle between the client and the subcontractor or supplier position. So you really want to be as transparent as possible and to be in a back-to-back position, so that if you end up fighting in court or before an arbitral tribunal, you can simply stay in the middle saying, okay, I'm transferring one side's claim to the other and vice versa. Talking of applicable law, some former colleague of mine who is not expert in international construction, sometimes they ask me, how can you have a project in Russia governed by English law? How is it possible? How can it really work out? Well, the answer is that, number one, our contracts are highly sophisticated and self-standing. After literally ages of evolution, today's contracts are really complete. Everything can be found in the contracts. So it's cases where you don't find your problem or your actual circumstance in the contract, and you have to look for the answer in the governing law are very limited. Number two, when you have to recur to the governing law, you have the governing law chosen by the parties. That said, you have to be aware that there are a few cases where the local law still applies, no matter what governing law has been chosen by the parties. We are providing you in this slide a short list of these cases. So you have the mandatory principles of that legal system that will apply always. And then you have a number of fields where the local laws apply for different reasons. Tax, for example, of course, if you choose to have your project in Russia governed by English law, tax provision, the Russian tax provisions will still apply because you are in Russia, and Russian government, like any other government, will never give up its rights and its entitlement to ask you to pay the local taxes. Labor and health and safety are another key principle. You can imagine if you can choose in a contract that for the labor issues, some developing countries' law will apply. It would be very easy to transform your workers in slaves, and this cannot be tolerated. Permitting, environment, custom duties, or all other very specific fields where local law will apply, no matter what have been chosen by the parties as governing law. Okay, Georgia.
This is another consideration that we would like to make. It's less technical and more practical, let's say. There are three aspects that cannot be altered without having an impact on the others. So, provided that the scope of work is to be understood. So when you enter into a contract, you define a scope of work. The contracts we are dealing with for the main are very detailed. So you have hundreds, if not thousands of pages of detailed scope of work with a hierarchy between different documents that establish what the order of priority is, but still gray areas that as far as the parties try to avoid still exist inevitably. There is the development of the scope of work during the first weeks and months of execution, particularly during when the process is developed, when engineering is developed, when the 3D model is carried out, when the ADSOP is carried out. That might bring to some deviations on the scope, whether or not formalized between the parties, so whether under a change or simply as something that is undetected, and that happens, that all have a substantial impact on time and cost. So let's assume that scope cannot be varied without using the contractual tools, the changes for better understanding. But again, for the main, there are many changes that are not detected, many small changes that all put together have an impact but are not detected. Then you have quality and HSE. These cannot be, these are a must. You cannot do anything but provide good quality, the first class supplies, and you have to stick to your contractual obligations as a contractor, so there's a little space of maneuver there. And of course, the safety is something that we cannot compromise in any way whatsoever. And so you remain with costs and time. And if the client wants to carry out a project in very short time because needs for financial implication, lenders, production, whatever is the reason, they need a project in very short time, the cost will be higher. But in this business, in the last years, and we will see that when we discuss also the Russian part on the third day, being a client's market, so the price is sort of imposed. The client receives from lenders and financing bodies a certain amount of money they can invest to have the project. They decide what kind of project they want to have, and that is the price, basically. So you as a contractor have to find solutions and ways to do that job in that time within those costs. Believe me, it's extremely complicated, and for the majority of cases, and we'll see that tomorrow afternoon with Nadia again, after Luigi's speech, mega projects tend to fail. So mega projects tend to fail because of the number of risks that have to be managed quickly without the parties to be ready to go up to speed with that. So if we observe the next diagram, it's about the transfer of risks, and this will be the main topic addressed by Luigi Di Paola tomorrow in the first part of our lesson. There is a sort of agreement at the beginning of the interaction between the parties. So I'm the contractor, and on the other side of the table there is the client. We establish in the very first day what kind of agreement we want to enter into. So do you want to have a lot of flexibility, you client, but then we enter into a kind of contract that is extremely flexible, but doesn't give you certainty about time and doesn't give you certainty about cost? Or do you want to enter, we go to the other extreme of a lump sum turnkey, a contract where you just pay an exact amount of money, you just establish a delivery schedule, and that's it. And then in theory, you after 4 years, you arrive, you turn the key, and everything works. Of course, it's not like that. There are many shades in between, and what we experienced is that majority of clients want to go for a lump sum turnkey kind of arrangement, at the same time keeping the flexibility you can have on a cost plus fee. So they want the best of the two worlds. And we have a project in Europe. I cannot disclose information, so it's not in Russia, but I cannot tell you the client, otherwise it would be disclosure of way too confidential information, where the client entered with us a cost plus fee kind of agreement, but then they are holding us responsible for everything, as if we are operating on an EPC lump sum turnkey. On other situations, for instance, my experience in South America, I experienced clients that just because we were operating in a EPC lump sum turnkey, they believed that everything that was happening under the project was our responsibility. We will see that tomorrow. It's not like that, but our work is mostly about managing risks. There are many interfaces, and this is something that we can address in the following diagram. And all these interfaces are somehow, interfaces and factors are somehow affecting the way we work, the way contract management is carried out, the way subcontract management is carried out, the way supply management is carried out, and so forth. We reiterate, and every time we go back to one point, we reiterate this, complexity is what we are bound to deal with. And if we are not, again, we go back to what Gianni Bardazzi stated in the very beginning, be adaptive. Our capacity as owners, as contractors, as subcontractors, to adapt ourselves to the different implications, the different angles, the different perspectives of the project is what makes the big difference between a bad project and a successful one.
Giorgio? Now you can, thank you, Andrea. Taking on from what you were saying about the complexity and all the sides of the parties involved, I would like to go back to the drafting of a contract point. You can imagine how difficult would be to have all this complexity and all these parties involved fitting just one contract. So basically, when you have to draft a contract, you have two choices. The first one is to go with an ad hoc, bespoke contract, which tends to be the rule in the oil and gas sector, based on my experience. Or you can use standard form. Standard forms are nothing but contracts already drafted, including all the typical provisions, which the parties can amend to tailor it to their own specific project. The downsides of the bespoke contracts are listed in this slide, so I let you to read it, and I will move forward. What I would like to say that, Georgia, please, there are a number of standard forms. Virtually all the international associations or domestic associations in different countries have drafted their own standard forms. Frankly speaking, there are a kind of business around these standard forms, because number one, the standard forms are sold for a price, and number two, the more famous and frequently used the standard form becomes, the easier it becomes to sell training courses, conferences, and a number of other initiatives about that standard form. And the master of this commercial approach, because I'm quite critical about that, personally speaking, is the FIDIC. Georgia, please. FIDIC is by far the most famous and successful source of standard forms. You are probably already familiar with that. It's a Geneva-based international organization. It was born in the 80s, and they basically started to draft standard forms starting from the ICAM model that was an UK, one of the UK standard forms, together with the JCT and the NEC. JCT is basically found in the domestic UK market. NEC is a standard form generally used by English government in public projects. The ICAM doesn't exist anymore and has been absorbed by FIDIC. FIDIC are used mainly in Africa, Europe, and Latin America. As far as I know, not that much in Asia or in the US. There is the so-called rainbow suite, because every standard form comes with a name of a different color, so the whole suite is named rainbow. The most important ones are the red, the yellow, and the silver. The red is used when the contractor is not the designer of the project, so it's basically for civil works, and it's mainly adopted in real estate and in building projects. Yellow and silver are used when the contractor is a designer, so EPC, turnkey. The main difference between the yellow and the silver is the risk allocation. Georgia, if you can please switch to the following slide. You can see that basically there is a different risk allocation and different scope of work for contractor and employer based on the different standard forms that have been chosen. You see in orange the employer's requirements, basically, and under the red book, the employer provides for the design. As I said, it's used for buildings, and in buildings, usually there is a reputable architect in charge of designing the building, and the contractor is just requested to build it as being designed by the architect. So usually in those kind of projects, there is a trilateral relationship between the client, the architect, and the contractor. And you can imagine the dispute between the architect and the contractor. You design something which cannot be built. No, dear contractor, you're wrong. It can be built, but you are too lazy to do that. And on the other, okay, there is the EPC turnkey, where the contractor is in charge for everything. I was mentioning the difference between the yellow and the silver is basically the different risk allocation. The silver book was drafted when the project financing stepped in the market and the banking, especially the world banking at the beginning and the private banks afterwards, were requesting a more risk-adverse standard form. So the difference basically are that, for example, under the silver book, contractor is responsible for the unforeseeable ground conditions, whilst in the yellow book it is not. In our sector, in the oil and gas, I have to say that there is something that is very risky, especially in the light of what Andrea was saying, meaning the overwhelming risk allocation on the contractor side, because Silver Book, the FIDIC Silver Book, has been considered for ages the most risky kind of contract that a contractor can be requested to sign. Now, honestly speaking, we face a step forward in this risk allocation towards the contractor, which is the FEED endorsement. FEED is the front-end engineering design, is a pre-design that the employer carries out on its own or by a FEED contractor, and the EPC contractor, which is requested to build a project during the tender phase, is also requested to endorse the FEED, meaning, dear EPC contractor, during the tender phase, you are requested to check the FEED and to sign that everything is fine and that the project can be built according to the FEED for this price and in this time. Now, when the FEED is fairly simple, it's not a big deal, but there can easily happen that the FEED is quite sophisticated. I can tell you that I came across a project regarding the revamping of an oil refinery in South America, and the FEED contractor had been working for something like 3 years for a multi-million contract, and the EPC contractor was requested to endorse the FEED in just 3 weeks. You can imagine in 3 weeks, it's impossible to check everything in a design that has been developed over 3 years. What is the problem? The problem is that under the Silver Book, I am accepting all the risk, but I am also in charge of the design. With the FEED endorsement, the design is basically carried out by someone else, and I am accepting the risk of any discrepancy, omission, or mistakes or errors. The last point that I would like to highlight and to make you aware that standard forms need to be amended to be tailored to the specific project, but this can be very risky because you really need a lawyer to do that in most cases, because changing, I mean, the standard forms looks like a clock, but actually is a clockwork. So changing a wheel somewhere will probably affect a number of other wheels somewhere else.
And that happens often, that clients and contractors believe they can tailor the standard forms to their needs, and by doing that, they create exactly what they want to avoid, and so gray areas.
Right.
I believe we already exceeded our
That's
time,
all.
and
That's all for now.
And we would like to address the questions received, and we would like to understand whether you have other questions. We're happy to remain as much as needed for making sure that the key messages of today's lesson are understood and are metabolized, and then tomorrow we can continue. Maybe we can start, Georgia, if you can address the two questions that we received. I've seen 2 questions on the group chat.
Yes.
So let's start from the first one.
The first one was from Shmakov, if I'm correct in pronouncing it.
If I make an agreement orally with client in the middle of nowhere field, how can I prove that I did everything right?
You can't. No, the point is that there always must be the contracts provide a way to formalize things, and this must be followed. So with a Russian client, actually, we at the very start of a project, we were notifying hundreds of letters potential changes. The point was that the project provided for the wording of the project say that any event that might have an impact and the contractor ought to be aware of is to be notified, and if you don't, you lose the right. So obviously, if the contract has been drafted that way, and it has been drafted that way by lawyers that have no practical experience on EPC projects, but just want to protect one side, create an anomaly of contractor that, in order to maintain the right to obtain a change, is obliged to notify any event that he ought to be aware and that might have an impact on the project. And if you don't do that in writing within a certain time frame, you lose the right. So anything that is verbal doesn't exist. Everything that you discover by chance, if you do not, that might not have an impact on the project, but still you have to notify that. The client was not happy of us sending the notifications because they believed that we were claim oriented, and we told them we are not. We are just applying the contract. So, do you want us to stop? Yes. Are you willing to change the contract? No. So if we stop sending this kind of letters, do we lose the right? Yes, you do lose the right. So I have no other option but to send you the notifications. So going back to the question, if you do it in the field verbally, you better go back to your office and tell the contract manager to send a letter to formalize in written that you received an instruction and ask the client or the subcontractor or whoever is your counterparty to confirm that instruction in written. The other question was?
Victor asks, could someone repeat what is the main feature of oral contracting on the field?
Pretty much, I think that I answered already to that question also.
Yeah. That's it.
Yeah, Victor, go back to the slide when you will receive them. Go back to the slide regarding the fact that contract is alive, the problem of amending the contract, the risk of amending the contract on the field by oral agreements, these kind of things that we discussed. So the problem is contract is alive. You need to keep track of all the changes that the parties agree down the road.
Okay, please don't be shy. If you have questions, we, as you can tell, we want to have an interaction more than a lesson.
Mi sembra che siano andati tutti via.
Hello.
Hi.
Do you hear me? I'm not sure that my mic is working.
We can hear you all right. Hi.
Thank you. The question is, which law of which country law is main law? I mean, if a contractor from a foreign country and a client is from Russia, so which law is in main position? I mean,
I try to, because then it's probably too technical, but I would like to give you an answer starting from my perspective as a guy who worked as a contractor for his whole career, and then Luca can give his point of view as a lawyer. despite my background as a lawyer, I was never a lawyer in my life, and I always worked as a contract manager. So I saw things from a different perspective. When you enter into a contract, we decide what law is applicable. So between Luca and myself, he's a client, I'm the contractor. I'm unable to be a client, so I must be a contractor. And we enter into a contract. I'm in the United Kingdom, he's in Italy. We can decide to have the Brazilian law ruling our contract. But then when you work into a country, like in Russia, you have to follow the local legislation. So between the parties, the relationship is ruled by the law that we decided to be ruling our agreement. Then the local legislation might, then there are some cases of like an Italian client with an Italian subcontractor working in Italy, not necessarily can decide a different law than Italian law. But let's say in our business, usually there is a lot of freedom. When you work in a specific country, then you have to comply with the labor law, taxation law, safety laws, and so forth. So there are specific, like when you import goods, when you issue drawings, they must be certified according to the Russian Institute of Design, in the case of Russia, and different institutes worldwide. So there is also the local legislation that plays a role. And there is also, as we are Italian, as an organization, I work for my organization based on Italian laws. So my contractual relationship with Maire Tecnimont is based on Italian laws. So as you can see, it's not one law only. There are many. I don't know if Luca, you want to see it from a different perspective.
No, I totally agree. From a technical point of view, I can just add that missing a choice by the parties, there are some international treaties providing for an answer to the question. So what is the law to be applied? And generally speaking, when a construction project, when it relates to a construction project, it's usually the local law. But this is just a purely technical and purely residual answer. For the rest, I fully agree with what you said. Also because you are my boss, so.
For practical reasons.
I always agree with you.
Your questions?
So, if you don't have another questions, students? No? So I have to say thank you so much to all our speakers. We had an interesting lecture. I hope that to the next lesson, our students will be more brave and I will ask you more interesting questions. So for now, thank you so much.
Thank you very much and see you tomorrow.
It was our pleasure. Thank you.
Thank you. Bye.
Good luck for the rest of your studies. Bye.
Bye-bye.
Bye-bye. Thank you.